Hi, welcome to the Divorce Allies podcast, a podcast and video series where we dive into all things divorce and focus on the process of creating a settlement offer with a team of professionals. My name is Melissa Gragg, and I'm a financial mediator and business valuation expert. I'm here with Victoria McCooey, our high conflict divorce coach. And in this episode, we're actually going to discuss the path of empowerment and self-representing in divorce. Basically, how to be prepared for a settlement as well. But Tracy Bee is our expert and attorney and pro se family court strategist. Welcome, Tracy. How are you?
I'm good. Thank you so much for having me.
Can we start off? We have a bunch of questions and they're great questions, but can we start off with what is a pro se family court strategist? Because I think our population may not know the opportunities that are there.
Absolutely. So I actually focus on strategy with pro se litigants or self-represented litigants. What does that mean? That means we actually work on whatever it takes to position yourself as a pro se litigant to make sure when you go into family court, you're packaging your case in a way that the judge and the court is more inclined to believe you, view it, and rule in your favor. So that's exactly what I do. And I don't just focus on law. I focus mainly on the practical, tactical, logical, and everything else that falls under strategy. Because as I don't know if most of you know, but family court is 80% strategy, 20% law.
Yeah, we love that because a lot of what we're doing in the Divorce Allies is strategy around the emotional, strategy around the financial. And you kind of come in with the strategy around the legal to specifically, though, represent yourself or go pro se. So that's self representation. But at the very beginning, we've talked to you briefly before this. What is the process to first determine if there's even that you can individually represent yourself pro se? Like, is it just anybody could do this process, or, you kind of have some guidance of how to kind of self-determine if this is going to be the right process for you?
Absolutely. First of all, I always preface this question by saying just because you could does not mean you should. Okay, because you do have a right to be pro se in any court in any state in this country, but that doesn't mean you should take advantage of that. In divorce or custody and family court, particularly, you should decide if you are going to be pro se based on a few things: your emotional and your mental. Are you in that space where you can actually handle all the emotional, all the mental? Because there's a lot of it. We all know that. And if you once you pass that muster, then you need to think about what it is you're capable of doing. Are you good at organizing? Are you good at research? Are you good? Because a lot of people will rely on research, quote unquote, research that does not pass the test. And so they wind up falling flat when they do research, what they call research, which is not adequate. So that's a huge part of it. And do you have the time? Do you have the availability to actually handle your case? And then we get to the issues. There's some issues that I do not encourage people to self-represent. And that is cases where there is parental alienation, mid to high level parental alienation. Absolutely should not be done pro se unless you have a team, a huge team that can help you with every single nuanced area of parental alienation. You should not do that pro se. And then there's some instances where there's been significant amounts of abuse in the relationship or the marriage. I don't know if that's something you'd want to do pro se. There may be some parts of your case that you'd self-represent, but from filing to finding, I don't think that that's necessarily the best scenario to handle your case on your own if you've been in an abusive relationship or marriage for most of the time that you were together. But anything else, some things like business valuations or property, where there's real property, or there's issues of whether something is separate property or marital property, those get a little complex too. Not to say that they're not pro se worthy, you just have to be a little bit more mindful. The good thing about some of those scenarios, except for parental alienation, is that if you are pro se, if you absolutely have to be pro se, there's so many other divorce professionals out there like yourself, Melissa, like you too, Victoria, that can help you supplement some of those things that you're going to be missing out if you don't have an attorney representing you. But yeah, there are some instances that you should definitely think twice about it. And my quiz, my assessment actually does that. It categorizes people based on their answers. It gives them a score, and it actually gives them some sort of sound advice as to which route is best for them.
Well, I'd love to know more about your assessment. But before I ask you that, you said research. People would be doing some research. What exactly does that look like?
Research should be things like, I notice a lot of people ask the most basic questions and they'll ask them from random people. When I see people do that, I automatically think they're not pro se material, because you don't know enough to know to go right to your court's website first, because that's the first point of research you should always do. Pro se or not, but definitely it's pro se. You should go to your county court's website and see exactly what they have there. You're going to find legal jargon. You're going to find the way their process is. You're going to find maybe videos, instructions. You'll find all of that. But beyond that, you should absolutely know how to do case law research. You should absolutely know how to do law research. And when you're doing those things, you should always play devil's advocate. You should always change positions. Put yourself in your opponent's position and research from that perspective as well. That's what I mean by research. That's what legitimate, valid research constitute. That's what it means.
And where would they go for law research, to research the actual laws?
There's websites like I think it's Justia. I think that's how you say justia.com. There are places like Nolo. Nolo is a good one. They have laws on theirs. And then sometimes the state's website has links to their own library of laws and regulations.
And I think a lot of courthouses actually have a library, right?
Some of them do. Some of them didn't reopen when the pandemic happened. Yeah. So a lot of them put their resources online entirely. And I actually think online is much easier than going into the physical library, because it's easier. I know
in some places they actually would have someone you could sign up for time with who could answer questions for you. They couldn't give you legal advice, but they could point you in the right direction or tell you what paperwork you needed to file or
Yes. California and Florida happen to be really good at that. Not so much, and New Jersey as well, actually. So,
yeah. And I think New York too.
New York too. Yeah. Some parts of New York. New York is not reliable. Yeah.
Even on the county website, a lot of times there's legal aid, there's other resources, and it almost looks like some of the legal aid is almost a national resource, like it's sort of national affiliations or something like that. So, I mean, but in essence, you have, like in order to be pro se or self-represented, you have to start advocating for yourself.
Absolutely.
A lot of what we're doing in the Divorce Allies is getting you mentally prepared to do some of that, because that's what I think you kind of said at the very beginning, is how do you even get emotionally prepared for this? How are you doing your research? This isn't a go hire an attorney and file day one. This is, hey, what are my options? And quite frankly, even when we have an options discussion, it's, well, you can hire an attorney and go the legal route. You can go collaborative divorce. You can go mediation. It's never really pro se, right?
Absolutely.
That's not the recommendation that anybody knows. And this should at least create that maybe some pieces you could do. Even if you engage an attorney or something like that, if you don't advocate for yourself, you're going to be in a situation where you're not going to have somebody that's really focused on all the issues that are important to you.
Exactly.
Right?
That is so key. That is extremely important. And I'm glad you brought that up, because a lot of what I do is encouraging people to make informed decisions. That means making them from day one, from minute one until the end, whichever route you choose. Just make sure you have the information so that the decision you're making is beneficial and advantageous to you and your circumstances. Absolutely.
Well, and part of that is like, let's say they've gone through the Divorce Allies. Let's say they understand, like, I think people are tired of the system. They're tired of hiring 2 attorneys, 2 experts, 2 of everything. And even collaborative, you're doing 2 of everything with a neutral, right? So in looking at this, if I think that I have the capability, what would be the process that I would start to begin representing myself? Like I take the form, I'm now a good person. Would I be working with you, or are there things that I can do on my own that would get me started in understanding this process?
Absolutely. Great question. Yes. The first thing you do is start the process. You get the forms, and that's why you're going to visit your court's website to see if they have the forms. If your county court does not have them, then your state court is likely to have them. You'll download those. You'll fill those out. You'll, correctly, because that's key. You'll pay the fees. You'll bring them to the clerk's office. You'll get the clerk to stamp them. You'll get your copy, and then you'll proceed with having the other party served, and then the ball gets rolling from there. If you're in a state or county like Tennessee, I think it is, they don't have a lot of their forms online. There's usually a nonprofit organization that might sell the packet of forms for a low fee. But most states in this country, I've visited every single one of them, have some means of getting the forms for free and actually starting the process on your own. Or you can just get me to do it. Yes, I can help you out.
What are some of the questions you ask on your assessment to figure out if someone's capable?
I always ask them about, and it's not, nothing's written in stone. I'm actually working on finding someone to solidify the mental and emotional part of it, because that is my background, but that's not my profession. But it does ask them about their mental. It asks them, and it's all self-assessment. So they get to answer based on what they believe is true. I ask them about where they are mentally and how they feel at this moment. And then I ask them about, their what they consider their strengths and weaknesses when it comes to organization and meeting timelines and things like that. So it's nothing that was created by experts in the field, which I do want to do that because I want to make it a little bit more research backed. But so it asks specific questions about, where they are emotionally, mentally, and then their personal strengths and weaknesses. And then I ask them, of course, about their cases and the issues that are involved in the case.
Because what I'm thinking is most people would not think that they were capable when they actually are.
You know what? Believe it or not, there are more people who come to me who think they are than there aren't.
Oh, really? The opposite.
Well, and sometimes I have to tell them, maybe you can start, because I always suggest, no matter what, I always suggest people start the process on their own. I really do. Because yes, absolutely. Because believe it, I can't tell you the number of people who've come to me and said, you know what, I've wasted $10,000 on the retainer. My lawyer hasn't done anything. It's already been 6 or 8 or 9 months. And a lot of the things that I was trying to avoid have already occurred because they delayed the starting process. And guess what? They've sent me another invoice because they've exhausted their $8,000 to $10,000. Nope. Save that $8,000 to $10,000, get it done yourself. And then at some point, if you feel the need, then you get a lawyer on board. Absolutely.
Right. So that's a lot. It's very aligned with our message in the Divorce Allies, because we're trying to get people to do all of the initial work, right? To gather everything, to get their mindset right, to get in the right headspace, to work on themselves so they have more clarity, and to start looking at it like a business deal. They're breaking a contract, and to take the emotion out and to gather all the right documents and have them organized. And then, just by doing that alone before you hire the lawyer, you've saved how many thousands of dollars?
Absolutely. And you've jump-started yourself. You like your mindset, believe it or not, having done all of that, whether you hire an attorney or not.
Now you know what you're talking about.
Exactly. You're empowered just doing that.
Absolutely. And that is our path to empowerment, right? Knowing so many people, especially women who come to me and have been in abusive marriages, they're like, I can't do one more thing. Like, I just need to offload this. Just tell me when it's over, right? I just can't do one more thing. And they're doing themselves such a disservice because they're at their lowest point. If they can start healing, start getting stronger, and then take on some of this initial work, so much better, because they're going out into the world in this compromised place, interviewing lawyers. What are they asking? They're just saying, tell me what I'm supposed to do. They don't even know what their issues are. They're not communicating anything.
I see
And
it
they're letting
often.
the lawyer drive this interview, right?
Yes.
The consultation, whatever. And they walk away. And now they're like, well, he seems to really want to take care of me. So I'm just going to let him do it, right? Or her, or yes. And they just want to find the person who is telling them, sit back and relax. I've got you, versus the person who can really advocate for them. So when you do all this initial work and you start understanding where the holes are, like, here's the money I know about, but I know there must be more. Where is it? I don't know. Now you have real questions or real issues to talk to a lawyer about, and see how now you can compare how they're all answering these specific questions.
Yes. Yes.
And I think
Absolutely.
it's interesting because one of the things is, are you doing your own research? Like, again, we have tons of people that have not gone to the court website. And part of it is, I really do believe that they kind of hide it under this pro se term and people don't know it. But let's go back to where you were. And now you got the documents, you're going down to the clerk's office, right? Or the court, and you're providing this, because Victoria had a good question about this. But when you're doing this, you're going down, you're going to the clerk, it's uncomfortable, right? They're going to maybe put you through, like, well, why do you want to self-represented pro se? Like, why are you doing that? Can you give us a perspective of how this self-representation is not only viewed by the court or by the attorneys, and has it changed recently? Like, are we more progressive? Are we more understanding? Or is it still sort of kind of looked at as a bad thing in the light of the court?
That's an excellent question. No, not much has changed. The court staff, the lawyers, they all still view pro se as the scum of the earth, excuse my language. But I'm really trying to change that, because you have the right to be pro se. And that is their way of gatekeeping, really. Honestly, that's all it is. Because they'll tell you, oh, we're doing this to protect you because we don't want you to, mess up your case or really destroy anything you might have been entitled to. The reality is, they want to keep the lawyers in the loop. They want to make the caseload and the court docket easier for the judge and the court staff. It's really about convenience. It's really about making things run smoother for the court, and nothing to do with the pro se litigant. Absolutely nothing. So if you're in, and I've heard some horror stories where people were telling me that the clerk would say, I can't tell you this. I can't even give you the forms. Go and get an attorney. I've heard this over and over again. Someone actually told me last week, oh, I'm not allowed to be pro se. I've already been told that I don't have the right to be pro se. And I'm like, are you in America? Because if you are, yes, you do.
Divorce is in the US is a $28 billion industry.
Of course.
This is how they feed themselves. And they don't want you not hiring an attorney. If everyone did that, they'd be out of a job. So yeah, they want to perpetrate this whole industry and perpetuate, that was the wrong word, perpetuate this whole money-making industry that they've got. So of course they're going to discourage you from representing yourself. And yes, that is exactly what happens. You go up to file and there's something incorrect, and they just throw it back at you, and they're rude and they're mean and they make you feel stupid. And when you say, what's wrong? Well, I can't tell you. Get a lawyer.
Yeah, exactly. Exactly. Which is another reason why we go back. And I love what you do, Victoria. It's the mindset, because you have to be determined and resilient and say to that clerk, listen, I corrected this. I would appreciate if you treat me as the public citizen, tax-paying citizen that I am, and answer this question or proceed with processing my form the way it's supposed to be done. Because the reality is, you have that right. No one should be telling you you don't have the right to. Now, we all know when bureaucracy gets involved, they have other ways to deter you and to discourage you. But again, if you prepare yourself mentally for that, then you're like, okay, I'm going to persevere no matter what I'm faced against, because I need to get this done and I have the right to do this and I'm ready to do this.
Right. I mean, it takes nerves of steel. You have to think of yourself as unstoppable. I mean, the whole divorce process and divorcing a toxic personality, that is the word that I always keep using, unstoppable. That has to be your mantra.
Yes, I love that. I love that. Absolutely. And I'm going to start using that with mine. Unstoppable.
Well, and part, like I started doing this a few years back, and it was met with, not happy attorneys, but there are a lot of the financial issues, especially if there's like marital waste, if there's spending that went too far. Like I tell the person, like, you're going to need to review these documents. You're going to need to outline and list or highlight all the issues that you think are important that should be highlighted, because the attorney is basically saying, I don't really want to deal with that. And I could charge you $10,000 to $20,000 to have to go through years and years of financial documentation to just pull out, okay, he had a dinner here, he had a trip here, and really getting them to advocate for themselves financially has been a struggle. But there are also a ton of people. I was like, if your attorney doesn't want to deal with it, just put it together and I'm going to say it's from me, right? I'm going to sanity check it against. But the amount of hours, I have clients that are like, I've spent 100 hours in doing these various things. And I'm like, think of how much you have saved yourself from 100 hours at $300, $500 an hour. And once you get in that process, you can't stop it. You can't say, hey, attorney, stop billing me, because that's not going to happen. So if we're in a situation though, and we have started pro se, and maybe we could work with paralegals, I don't know, you can tell us, are there points that we would then want to seek an attorney if you've started pro se or self-represented? Because I think that we have to start to understand that this is a bag, like it's a mix of people, and an attorney is part of your team that you could have, or a legal advocate, right? Because that's kind of how you fit in. You have the legal perspective,
Yes.
but you're advocating that the person represent themselves in some capacity, right?
Yes. So at any point, you could get an attorney. That's like music to any judge's ears, right? I need another date to come back because I want to hire an attorney. Yes. If you want to win favor of a judge, say those magical words. But in reality, if you're getting to the point where you're feeling like nothing is working, whether the other party is pro se, especially if the other party is represented and they are represented by a quote unquote bulldog attorney, or the attorneys that are so seasoned at being manipulative and cunning and all of those things, then you may want to consider that. If you're not comfortable dealing with an attorney, whether they're a bulldog or not, really being persistent and really being assertive, borderline aggressive, then you might want to get an attorney. If you have issues that are becoming way more complex and the other side is not open to any sort of reasonable negotiations, then you might want to get an attorney involved. And when I say get an attorney, you still don't have to have the attorney represent you until the end. You can get an attorney on a limited scope basis. You can have an attorney just serve specific purposes in your case. That is being strategic, is knowing, hey, for the next couple of hearings, I'm going to have an attorney involved. And then after that, I'm going to go back to being pro se again. If you're in before a judge who is really biased, and they've been really obvious and open about their bias against you or against you based on the issues in your case, you may want to get an attorney involved. At some point, when you get to the point where you see that your case is going to suffer because of whatever it is, and you've tried every other avenue to resolve or address those issues or concerns, you might want to at least consult with an attorney, hire one on a limited scope basis, or just retain one full out.
Yeah, I think that's helpful to understand that there's a middle ground, because I think that everybody's just like, I hire the attorney and they're going to take it from here. And that's the process, like, quite frankly, the attorney understands the legal. Where I see more of the manipulation is in the financial. The attorney doesn't even know the financial. I mean, I just saw a situation recently that there's a mediator, there's a court appointed expert. They're looking at different things. I come in and there's literally 8 to 10 red flags, just very immediate. Like, not only is it manipulative, it is manipulative in so many areas that it is just on its face ultra biased, right? And this is a situation where the mediator should be in the middle, the evaluator should be in the middle, the expert should be all of these people should be servicing both parties. But there were even meetings that were done with one party and without the other, right? And then this huge settlement offer is produced. That's not in the middle anymore, right? Like, you have to start at least identifying, if you're currently in a situation, what are the red flags that you're experiencing? What is your intuition saying? I shouldn't do this. I don't know why, but this doesn't feel right. And how do you support that and get some assistance? And you kind of have some of that, as well as resources, because one of the things that you talked about that in another podcast that I thought was freaking brilliant was the resources for researching that we talked about some of those, but I want to go back to the theory. Yes, there's LexisNexis and all of these court cases that you can research, but you talked about researching the judge. You talked about researching some of the cases that either came through with the judge or the other attorney, and then preparing for these hearings, which realistically, most of them are status updates, settlement hearings. They're literally 5-minute hearings that you're just showing up. Hey, did you do what you were supposed to do? Or there's other hearings like PDLs or temporary maintenance and child support that are very important that come at the beginning. So how do you kind of get them framed up? Let's say I'm ready. Like, I got to do this because I don't have access to the money to even support a full team at $10,000 a month, right? Yes. How do you kind of get them so that these beginning hearings, which are nothing, that they can kind of successfully get through some of that beginning process?
Yes, some of what you just said. I always research the judge. I always research the judge to see what logic or what frame of mind or what their basis is for making rulings, specifically in cases where the issues are relevant to my client. And if there's an opposing counsel, I always research the opposing counsel. As I look at their prior cases, I look at what argument they took or what position they took. If I'm in an area, my client is in an area where I can actually talk to lawyers who've dealt with that other lawyer, then I'll ask about that. I always ask clients about the courtroom dynamics, because believe it or not, that has a play. If the courtroom dynamics includes a court attorney or something similar, excuse me, which is someone who really, in some jurisdictions, they make the decisions. It's not the judge, it's the court attorneys. So I always find out if there's a court attorney or someone's a law clerk or something similar. I always want to know, where did they go to school? I look at their background, where did they come from? Because a lot of times these rulings are not based on law. They're based on what the judge's preference is that day, where they came from. If they came from an area of law that, where there was no transactional stuff, and then now they're in family court doing, handling these kind of cases, or if they were in corporate law and now they're actually having to learn how to apply civil rules. So all of those things matter, and it helps, because hearings are about the actual performance of them, the actual logistics of them. It's the actual playing out, and because a judge can actually say, good job, you have all these documents ready, but I'm not going to see any of them because they're precluded. So now how do you figure out whether or not all of these documents you have, if you should even bring them? Are they even going to be seen or heard or included into the record? A good way of knowing that is knowing your judge, is understanding how your judge applies the rules of procedure, applies their own rules in the courtroom. So a lot of hearing preparation has to do with the logistics of the dynamics of the actual courtroom, the way it's going to play out, from who's there to, like I said, to how they're going to apply the court rules of procedure. Because again, it's not necessarily about the law. It's going to be how the judge chooses, the basis the judge chooses to make their rulings. And sometimes the implicit way is just by saying, I'm not going to let your evidence in because it violates the rules of evidence, which we know it doesn't. So, and I walk my clients through that. We go through it all. We're going to go through it piece by piece, because the reality is, if one hearing could set the tone for the entire remainder of the case, whether that hearing is on child support, temporary alimony, whatever it is, it's going to set the tone. Those temporary orders sometimes become final orders, and people need to be aware of that. So they may say, well, it's only a temporary order. It's going to change because we're still going through the proceeding. No, judges are lazy. They don't really want to do any extra work. I'm serious.
Do you know what I hear all the time? I hear people telling me their lawyer said, oh, this doesn't matter. We don't have to worry about this. It's only temporary. And there is something called status quo.
That's right. Exactly.
Judges don't want to do any extra work. It's like, if it ain't broken, don't fix it. Right. So, yep. This is what you've been doing and it's been working. We're just going to keep doing it this way.
Exactly. We also see it as a first indicator. Like if you go to a PDL, which is a temporary maintenance, and they issue a temporary maintenance, that's an indicator of where they're geared towards for the rest of the trial.
That's right.
But let's stay on judges for a little bit, because I do love this conversation. I think that you have to look at judges when you go into the courtroom, the judge looks like this, like omnipresent, like, and you're like, you start to play, like you got to look at the judge as if they're a person, and you have to understand that they're going to default to logic. And so the more that you don't have to go in with legalese. You need to go in with logic, with positions that make sense, that are easy to understand. But a couple other things you should know about a judge. When you're doing your research and they're a baby judge, which means they've only entered the family law system recently, and they may only want to be there for 2 years so that they can go be a fancy judge at some point, right? That baby judge, you have the opportunity in most situations to kick the judge, to get a new judge at some point in the process. And usually it's at the beginning that you've identified that that's not very aligned. If anything, I think that would be a way that they should work with you to even understand initially, is this the right judge or is it not the right judge? The second is, each judge, when they're assigned to your case, have a courtroom. Like it's the same courtroom that they always operate out of. It is listed in the courthouse. It is an open, typical courtroom that you can go that day. When you file your paperwork, or they assign you a judge, because it's not always the same day. Once they assign you the judge and you're in the system, go to that courtroom. Go see where things are situated. Go see, you can walk right in. There might be a bailiff there. They might ask you what you're doing. Just be like, I'm just looking. See where people sit, see where people stand. So it's a familiar kind of space. We did this once because I kind of testify around the country. And there was once that we went in and I checked everything and the chair didn't move, right? And so I just had to know. Other expert comes in, local expert, right? Walks in, tries to move the chair out of the expert box. And I was like, oh, that's cute. You've never been here before. You haven't been in front of this judge, because you would never have moved the chair like that. We go in as an expert, sitting in the same place, right? So understand where you're going to sit. Hey, the bailiff has nothing else to do. They're literally sit there all day, whether the judge is there or not. You might be able to ask them questions like, well, where does the parties normally sit? Oh, right here. Where does other people, like in some states like Georgia, you could have a jury trial for a divorce situation. So again, understanding, is that in your benefit or is that not in your benefit? Some of those beginning things can be very helpful if you're just taking the initiative and understanding that these places are not closed to you. These are public domains that you can see and prepare yourself so that when you walk in there, you are confident. You do know how far up they're going to sit, right? Where you're going to stand. What is the podium for? Things like that. It's if you know some of that space when it's ready for you to perform and you're nervous, you don't have to worry about where do I park? Where do I come in the, like, you got to go through security. Hey, in some courts, if you are not an attorney, you can't bring in your cell phone or your computer.
That's right.
Like, I operate in a lot of smaller towns as well. And they've had issues where somebody's recorded inside the courtroom and they don't allow any of it to even come in the courtroom. You will have to go back to your car and drop that stuff back off. You know, like, I don't know as a pro se if that, but as an expert, I sometimes try to act like I'm the attorney, but they'll still stop me and say, what are your credentials? You can't have recording devices. So now if you have to go back to your car and you just walked 15 minutes in high heels and now you're sweating and you're going to be late, those are all the things that you want to prevent with like these trial runs of what to expect when you get there.
Absolutely.
Right?
That is such good advice, just having a lay of the land.
Yes.
And to add on to that, I can piggyback and start the night before, like plan the night before even. Right? You're going to know what you're going to have for dinner. You're not going to have alcohol. You're going to drink a ton of water.
Yes.
You're going to take a bath. You're going to do the things that set you up for success. You're going to get up way earlier than you need to. You're already going to have laid your clothes out. You're not going to do this last minute, oh no, this looks bad. No, maybe I should look this way. Maybe I should look that way. You're going to know exactly what you're going to put on your body, and you're going to leave really early, and you're going to have time to stop and have a cup of coffee or whatever. And then you're going to visualize all of the things that are going to happen beforehand.
Yes. The only thing is, since the pandemic, a lot of courts have used that as an excuse, as a reason to deny access to courts. They've closed, a lot of courts have closed public access to them. But what I tell people to do in the interim is, or as an alternative is, as you said, there's a lot of courthouses where the court personnel, the court staff, even the bailiffs or the court officers are familiar with judges. Bring them some coffee and have a conversation and ask them, what do they think about the judge? What are their experiences? What do they know? What do they have the propensity to do? What they like, what they don't like? That's the next best thing, because you have to have some insight about your judge, the layout of the courtroom, et cetera, et cetera. So very, very, very good points. Thank you, Melissa, for
and some of those clerks will be helpful in some capacities. The other thing that I will say is bring water and snacks, because you might be there for a while, and the court food is always horrible. One of our courts, the guy is like kind of blind, and I was like, I don't know if he knows how to make coffee. I don't know if he's just pouring it in there. He's a sweet guy, but that coffee is sometimes off. So the other thing, though, is that a lot of these hearings, because of the pandemic, are done online.
Yes.
And they're done online in this very awkward, not great way that you're in there with everybody else who is waiting.
Yep.
And I've had several times where clients were not let into the room. Then it appears that they were not there. So I think at least with the clerk, understanding, okay, what is the process for an online hearing? Can you give me, because they have directions, they have all of this. Get that information so that you are not late. How do I make sure that I don't miss this hearing, especially if that maybe my spouse is represented and then they kind of blame you in some capacity. So a lot of it is preparation and proactiveness and understanding that this is a freaking marathon and you have to plan and prepare for it. It's not for the weak, for sure.
Exactly. Absolutely. Yes.
Okay, so we have some weird questions or kind of like crazy questions that will kind of round it out, because I know we've been talking forever, but I just love this so much. So we have a question from somebody like in our Divorce Allies, and I think Victoria can give some additional knowledge to this as well. But like, what if you're representing yourself and now you either need a psych evaluation because you think the other person is woohoo, or you need a specialist because like a vocational rehabilitation specialist, a GAL, which is a guardian ad litem for the child, like how do we get them involved if either no attorneys are present or if one, is this a normal process? And then like who pays for it? Because if I don't have access to the money, how am I getting into the court to explain some of this? Or is there a process?
Absolutely. So for the most part, before you request any of these, make sure you know what the rules are with regards to them, because every single court has these psych evals and specialists. There are provisions in the court rules of procedure regarding them. So you have to start there. Find out what that is, because you can't, or you shouldn't, go to court requesting a psych eval, not knowing what the criteria is for the judge to appoint a psych eval. And you, as pro se, you can ask the judge, hey, judge, if the judge would be inclined to appoint or assign a psych eval, or give me a court order to have a psych eval done of the other party. And then you're going to go and explain why, knowing what the criteria is for the judge to do that in the first place. You have to know that, because what I see pro se litigants doing is they'll say, oh, undiagnosed now. They'll say, oh, my soon-to-be ex is a borderline personality and he does all these things, and they don't have anything to base that on. They're just, using some pop culture mental diagnosis, and then and judges are really not a fan of that. So know what the criteria is for getting a psych eval or getting any specialist involved. And then if you know that you meet those, make sure you explain that when you're requesting it. Make sure you're explaining that, not, hey, judge, and I met the criteria. You're just going through the criteria to ensure that the judge is aware of the fact that you know what the criteria is. And then when there's an issue of having access to funds to pay for this, again, the criteria for having one party pay for something, especially when it's the opposite party requesting it, that's a challenge. So you're going to have to make an argument as to why you meet the criteria and why they should be the one ordered to pay for it, despite the fact that you're the one requesting it. And it's usually, it varies. It honestly varies based on who the judge is, because some judges will, buy the argument, but your argument should always be, if you have strong reasons to believe that this specialist is going to help you and it's going to serve the court in some way, it's going to speed up the court process, it's going to lighten the burden on the court, it's going to make sure we attempt at resolution or settlement are easier. Again, those are buzzwords for the judge. They're always going to want to hear those things. So do that. And if they're not inclined to entertain your request and verbally, you have the right to file a motion at any time. You can file a motion.
Okay, go ahead.
So a lot of pro se don't know, you can file a motion for anything. You don't have to use pre-formatted motions, right, that you find on the court's website. You can file a motion and just make the caption, request to have a psych evaluation done of, and put the whoever that is, the respondent, the defendant, the plaintiff, the petitioner. That's it. It's that simple. And then and I actually prefer that, because I prefer motions, especially when you're pro se, over making verbal requests. You know why? Because you're making a record. Because if that motion is denied, now you can, re-argue or resubmit the motion by making corrections. When you do a verbal argument and the judge denies you, you're done. There's no real recourse. So sometimes you can say you're going to follow up with doing it by motion, but some judges will automatically reject that as well. So
interesting.
That is really interesting. I mean, that kind of blows my mind. If I summarize it, though, if you understand the laws and statutes around, getting a specialist, you need to, again, a lot of what we're saying is you need to summarize what the issue is. You need to have proof of why you need it and why the judge should order it. If you argue that, for payment or how it could be a settlement offer, and then also not going into the judge and saying, hey, judge, I was thinking that I need a specialist. How do I go about doing that? No, this is, you need to do all of your research so you go in, and then filing a motion makes so much freaking sense, because if they are biased against you because you are pro se, it's establishing a record that either is, potentially appealable if they didn't allow it and it should have been allowed. And you don't even know at that point, right? Because if the judge says it, you're just like, okay, I guess it's the word of God. But the reality is, if you document it, that's going to be, and in the documentation of that motion, you probably had to go through these steps to understand the law, present it, proof, summary, and all of that, right?
Yep.
I
That's
think the
exactly-
misconception is people think that in order to file a motion, they have to know which laws and cite case law and all these things that they think I'm not capable. I don't know how to do that.
And that's not true.
And it's not true.
Yes.
Well, can ChatGPT help us?
Not with research. It can help you formulate the motion. And I'm working on an AI workshop just for pro se litigants, and that's one of the main issues is looking at it for research, and it's not reliable. It's still not reliable when it comes to research. Not for the laws, yeah, and the procedural rules, but not when it comes to case law, supporting case law. It's getting better, but it's not quite there yet.
Yeah, it's better for taking, like, a lot of times what we will kind of say or have our clients do is write down a bunch of this stuff, right? In whatever format that you want it, and get it out into paper, and then take that and run it back through ChatGPT so that it's like, even frame this up as a motion, right? Like, you can even direct ChatGPT to take this information, frame it up as a motion that then I can file, or a letter that I can send, and all of those things. It really helps things be more concise.
Yes.
And I think that at the beginning, people are just like in 18 different ways trying to move something forward, overwhelmed, by the process and things like that. Right.
Yes, I totally agree. I did a motion on ChatGPT because I'm curious. And it was for someone who's all over the place. And like you said, and really not cohesive and coherent in their arguments, it was really helpful in narrowing things down and making them a little tighter. Again, I am, I'm anal when it comes to making arguments. I love being strategic in my arguments, and ChatGPT failed in that respect. But for a pro se litigant, yeah, I think it did a really good job of doing exactly what you just mentioned. Yes.
Okay. So another question that we have that is kind of the reverse of what I think about, but Victoria has this great question. What are some of the issues if a person would face if they are represented by an attorney, but their spouse is pro se? And are there any like things that they should avoid in those types of situations?
You know what? I've seldom seen where a litigant who was lawyer represented was at a disadvantage when the other party was pro se, if that puts things in perspective, honestly.
I have a client right now in this situation, so I can tell you some of the hurdles we're facing. He is delusional, right? He thinks that his arguments are sound, and he wants things that are not realistic. And there's no one to tell him that he is trying to get something that's impossible to get, right? There's no buffer. He has obviously no worries about legal fees. So his constant letter writing and petitioning and motion practice is costing her a ton of money. Nothing's happening. He's not turning over discovery. Nobody is gatekeeping him, right? It's like, it's the Wild West with him. And she's incurring a lot of fees. That's the biggest issue.
Which a lot of them do. That is their strategy. I've had clients come to me and say, this is my strategy. I want to be pro se so that I can run up his or her bills, lawyer's fees. Yeah. Guess what? As the lawyer, though, it's that lawyer's job. A lawyer goes into a courtroom and tells a judge, this pro se litigant is delaying things. This pro se litigant is not cooperating. This pro se litigant is making things really difficult. Guess what happens? Now you've been sanctioned. You've been precluded from this. It's not advantageous to him at all. It's not. It's not going to end well.
Well, I think it is helping illustrate the mental illness and mental incapacity. Because did you remember the Darrell Brooks trial, he was a very narcissistic guy. He was in Waukesha, where he ran over the people in the Christmas parade, right? And he represented himself. I mean, that was the perfect illustration of how this is not a person who should be representing themselves.
Yeah, and that's what judges will use. They'll use scenarios like that, where those are extreme. You know, I've had clients who would like that. they were extreme. But the reality is, it's the lawyer's job. The lawyer has the upper hand.
Yeah.
No matter what.
Like the lawyer is the problem in some of these situations, because again, these are delay and distract tactics that are just running up the lawyer's bill, and they're okay with it. But what you have to do is you have to just follow the rules. You have to be prepared for every hearing, no delays, no continuances, and it shows a story to the court. If they come in and they want a delay, then they're doing it in the court system. I need a continuance. I need more time. And you're like, hey, judge, we're ready to go. Hey, judge, we're ready for a trial date. Hey, judge, we've complied with everything. And in my mind, that's when you really do everything you can, because there is no negotiation in this process. It is, here is our settlement. Here is our offer up to the court of how things should be settled and finalized. And you are just on a path to trial. And if you just stay focused on that path to trial, then all of the delays and distractions shouldn't matter. They should only be sort of addressed at those hearings when you're going in and saying, oh, what's our settlement status? I'll tell you what our settlement status is. And judge, we are ready for a trial date. And judge, we are ready for a trial date at all times, because a lot of times those settlement hearings are just to give you more time until they give you a trial date.
Sure.
Right?
Sure.
That's how it could be 12 months, 18 months down the pipeline. It's not like you file and they get an immediate court date. You know, like the judge is going to want to be like, hey, are you guys ready for a court date? Oh, you're not? So have them establish that story in a very recognized fashion.
Absolutely. I totally agree, because at the end of the day, that's exactly that's part of their tactics, their strategy is doing exactly that.
So Tracy, in your position, do you think more judges are more lenient toward pro se people going through divorce, or do you think they're harder on them?
I think it depends. I've seen some judges myself be really, really patient and considerate with pro se litigants. I'm going to tell you a little secret. A lot of times it's who the judge is or where they come from. I've noticed that judges if you're dealing with a family court judge who's been in domestic violence 10 years before they got to the bench, they're going to be more compassionate for pro se litigants. If you're dealing with a judge who worked for the public defender's office in the criminal sector, they're going to be more compassionate towards pro se. For the most part, I don't like to generalize, but for the most part, if you're dealing with a judge who's come from the prosecutor's office, right, they're probably not going to be a fan of pro se. So a lot of times it depends on who they are, where they're coming from.
That's interesting.
Well, and quite frankly, just like if you go to another country, here's the best analogy that I can provide about judges in my perspective. If you go to another country and you attempt to speak the language, they're going to see that as amazingly credible, and then they're going to capitulate and maybe help you and speak English, right? So if you're going to enter into the courtroom, you need to be prepared. Are you following the rules? Did you do your research? Judges are procedurally very OCD. So if you're coming in and you can talk and that's your time to speak, and you speak and you attempt to speak the language, and not in legalese, but attempt to operate within the rules of the court, they will see you as trying to put your best effort forward and be understanding.
Absolutely.
If you come in and think that the judge works for you and should provide something, that's when I think you're going and you're like, well, I'm just trying to understand the process. Nobody comes in the court and asks the judge what the process is. No attorney, no anybody. So you kind of have to come into this space very like, I don't think that you can do it without some coaching. Like we know you can't even go to a mediation or a settlement offer meeting without preparation. This is this is like the Olympics. Like
Yes.
if you're going to do this, there are strategies that are going to make you very successful.
Absolutely.
And there's also, it's such a dime that flips that if you don't do them, they're going to make you enemy number one.
That's right.
And that's part
right.
of kind of the process.
And be
But
consistent, because judges don't remember you from a month ago and that you were the one that they deemed not toxic or not the high conflict one. So you have to maintain that mentality, that sense of presentation every single time you're there.
Oh my God, that's my phrase, right? Create contrast. You're creating the contrast from the other litigant, right? You wear the white hat, you're the good guy, you show up on time and you're respectful and you always do this, you always turn things over on time, you're always, always. And then they're going to go, oh, right, that's the good one, that's the bad one.
That's right. Absolutely. That is important. That is huge. That is huge. I've had conversations with judges like right before litigants walk into the courtroom, and they'd say, if the both attorneys are in the room and maybe the guardian ad litem and any one of us shares something about something that happened with our client, maybe 10 minutes prior or whatever, that can actually persuade the judge either way. So, you know what I mean? So it indicates, and it actually persuades them to do or say something that implicitly, not explicitly, implicitly has an impact on the overall outcome that specific day. So if you're mindful of that, you're going to be the contrast. You should be the contrast. You know, just putting that in perspective for those who want to go in there pro se, you have to know, hey, wait a minute. This judge doesn't remember me from last week or last month, but they might have been tipped off by something today and they're going to change position today. Let me just maintain my consistency with being the contrast.
Let me just boil this down. I think the perfect process, path to empowerment, is to, even if you don't follow through with it, to assume that you're going to be pro se. Start that way. Just presume that, and you do all the research and you get all the information and you do as much as you can before knowing you can hire an attorney at any time. Why not get as educated as you possibly can about your case?
Absolutely. I love that. I absolutely love that. And because it presumes so much. It actually takes on a persona of itself in so many ways.
Now you're not going to be asking the lawyer every question about everything. You're going to know already.
Yes.
Yeah.
I kid you not, the number of people that will come to me and ask the most basic questions. And someone asked me some basic questions last week, and they insisted on doing this entirely on their own. And I said, the mere fact that you're asking me this is telling me you're not ready. You're not pro se material. And they got so offended. And I'm a straight shooter. I'm a native New Yorker. I don't mince words. So a lot of times it's hard for me to pretty up my responses. But she really got offended, and I'm sorry, but you're going to go and you're going to be annihilated. You're going to be annihilated.
Well, and this is probably the last question that we'll ask before we talk more about your process and kind of close it down, because this has been a lot of good information. But I will tell you, and Tracy and I have talked about this, but as an expert witness, and I operate in the court system and in the mediation spaces, I have not received the best support when I have helped clients advocate for themselves. So when I've really said, go out and do some of this work yourself, question these attorneys and do all of this, it really does kind of put a mark on your, professionally. And because pro se and self-represented is really not where even attorneys, I mean, you can ask attorneys, be like, how do you do that? And they're like, I don't know. Like, what do you mean? You hire me. This is how you do it. So if other people, like, we've geared this podcast towards people who are going through divorce, but there's a lot of other experts that are in the field that don't know litigation as much as they maybe know mediation, or they're outside of the courtroom process. How can experts like us support people who are interested in self-representation or filing pro se? And how can we start to unite in some capacity to really start to put the empowerment back in the couple or the individuals so that they can go around the system or use the system in a more efficient way? What can we do to be more supportive?
a lot of it is our own mindset. And it's funny. It's so interesting that you're bringing this up, because that's exactly what I'm working on now. Is when I literally decided to work with pro se litigants, it took 4 years, 4 or 5 years for me to actually shift my mindset to understand the needs of pro se, to understand their language, to understand exactly what it is they're trying to accomplish. That's not an easy task, especially when you've been programmed to think that only lawyers can help them. So I would love if divorce professionals would become educated. They need to be informed. They need to be informed that there's options. There are options out there. If you don't feel comfortable advocating that some clients should be pro se or could be pro se, maybe you can make it advantageous to the other people who are creating the resistance for you. Because yes, I don't have a lot of my colleagues now saying, yeah, Tracy, good for you. But what I do is I say to them, hey, just because they can mutually exist. I'm not telling them that they can't hire a lawyer or shouldn't hire a lawyer at any time during their pro se representation. They may need you, and I might need you. So I'm not cutting into your pocket. I'm not cutting into your interest. We can still make sure your interest, to an extent, because I am a pro se advocate too. We can still do that. They can mutually exist. But I really believe that being informed about all the options, all the possibilities, all the benefits, and how we can work collectively, because we should be in this together to serve the same clientele that we're serving. And whatever that takes, no offense, but whatever that takes, that's exactly what we should be doing. But having information is it. I spend most of my time right now educating, not just pro se, but divorce professionals in the legal community about the actual benefits of being pro se. I think if we all took that responsibility on, that would actually change so much for all of us. With AI coming, the legal landscape is going to change drastically. So we need to get on board. I was so anti-AI up until this year. There is no way around it. They're being addressed in legislations and bar associations because it is going to make a huge shift in the legal landscape. Trust me.
And quite frankly, if everybody played more above board and we weren't trying to use the legal system to manipulate people in some capacity, like I'm hoping for a global reform of the divorce process and maybe like a unified process. Like you come in with stuff and you split it evenly, like things like this could really create, and that's where it's going to move. When there's no money in it, then it's going to move to a more efficient pattern. And that's where we kind of see. So I think that this has been amazing. I want to show people how to get a hold of you and all of us. Could you tell us a little bit more? Because I will tell you already, you have training programs, you have mentorship programs, you have downloadable things, you have videos, you have all of this already built. Like you have been actively doing this. You have staff, you have people really helping people around the country. Can you now tell it in your version of why they should come to talk to you?
Because yes, I do have all of that. I have every single topic we've discussed today, I have some sort of resource to help people. I mean, it's a downloadable, printable resource where it gives you step by step. And my thinking, you want to get into my brain. You want to get into my brain in any way that you can. And that's tapping into listening to my podcast, reading my blogs, becoming a client and working one-on-one with me, and having access to my courses and my workshops and my guides and my worksheets and my workbooks and all of that. But yeah, those are, and I have some other things coming that I'm not going to talk about just yet. That's going to be a surprise. But yeah, those are the main ways to actually get into exactly what it is I pride myself on providing for pro se litigants. So yes, if you go to my website, it's all there.
Well, and that's amazing because you kind of cover the legal. Victoria's over here kind of covering the emotional and working through high conflict. I'm over here handling the financial. And really, those are the three big parts of this whole process. And again, I really appreciate you spending an entire hour with us. And this is such good information. We'll probably still have you on for another session to talk more
Sure.
about what to actually expect, because I think that sometimes clients really want to know, like, what do I expect when I get in that courtroom, when I get
Sure.
into that hearing? So we appreciate you, and we'll look forward to talking again.
Thank you. Take care.
Bye.